Did he mention that who has coerced him?
Pardon?
Did he mention that who has coerced him?
Who has coerced him?
Yes.
Well, he didn't. He just used the word martial authorities. Because the martial law, General Zia-ul-Haq was in power, and it was all orchestrated. The malicious design was orchestrated by General Zia-ul-Haq to execute Shaheed Zulfikar Ali Bhutto.
You mentioned an application being filed by your client, but that was not filed by you, or was it filed?
It was filed by me, I think, in 2018.
Yeah, Biju filed ki. That's by Mr. Raza Rabbani.
No, my lord, I filed this at CMA in 2018. I'll give
No,
the
now.
Now अभी तो मैंने कोई फाइल नहीं किया है.
No,
अभी मैंने खाली live stream.
You filed it, or Mr. Raza Rabbani filed it?
I filed it, my lord.
Okay.
And recently I filed an application for live broadcasting.
Okay. I was in impression that Mr. Raza Rabbani has filed.
No, I filed it, my lord. Thank you.
Ji, please continue.
From paragraph 9, my lord. This admission tantamounts to violation of constitutional oath of office which reads...
No, we skipped the oath.
Naseem Hassan Shah's book, Constitution Law in Pakistan, pages
Constitution
52 and 53. Kindly read. And
Constitutional laws.
His book is Constitution, Law and Pakistan Affairs.
And Pakistan, and published by?
I do not know, but it's written by
Pages?
former Chief Justice.
Pages? 52, 53.
Pages are 52 and 53. And how this judgment was compiled, everything is written.
Mr. Farooq Naik, why are you so far away? We don't want to keep calling upon you or send some junior forward. And we would like this book to also, because he has referred to...
Can you read it?
No, we won't read it now. We'll let us finish the reference, but these things keep coming up, so we'll want to see the actual book. Please proceed.
This admission tantamounts to violation of constitutional oath of office which reads as under.
So skip the oath, we can move on.
As such, Article 6 of the Constitution of the Islamic Republic of Pakistan is fully attracted in this case. Next para.
Then there is a statement of Naseem Hassan Shah in Nawai Waqt, Justice Zia-ul-Haq is इंतहाई मुश्किल हालात में अजीम फैसले दिए Naseem Hassan Shah.
So where are you referring to these things?
This is 2nd of March 19.
No, this paper book, what is in your hand?
ये मैंने फाइल किया हुआ है.
Okay, it's on the record.
It's on record.
Is there a number to it?
Its number is 57888-2011.
578
CMA 5788 of 2009 and filed on 31st of December 2011.
2011. Thank you.
Kasuri sahab, आप फॉर्मर चीफ जस्टिस नसीम हसन शाह साहब के स्टेटमेंट पर रिलाई कर रहे हैं?
नहीं, उसने अपना स्टेटमेंट
उन्होंने जो स्टेटमेंट
तारीफ कर रहा है जी सिद्धार्थ,
उन्होंने जो स्टेटमेंट्स दिए
बल्कि
सुन ले
अपनी किताब में लिखा है अपनी किताब में लिखा है कि चीफ जस्टिस ने कहा हमें चारों जजेस को एक क्वेश्चन दिया कि अपने अपने जजमेंट देखो. जजमेंट को उन्होंने कंपाइल किया.
नहीं, Kasuri sahab, thank you for pointing this out. Attorney General, can you continue reading?
My lord.
Because
paragraph 10.
Yes.
It is important to point out that in Sindh High Court Bar Association versus Federation of Pakistan, PLD 2009, Supreme Court 789, while dealing with the cases of the judges who had taken oath under PCO, the Honorable Supreme Court at page 805 held as under. The judges of the Supreme Court of Pakistan, if any, the Chief Justice of the High Court, if any, and the judges of any of the High Courts, if any, who stood appointed to the said offices prior to 3/11/2007, but who made oath or took oath of their respective offices in disobedience to the order passed by a 7-member bench of the Supreme Court of Pakistan on 3/11/2007 in CMA number 2869 of 2007 and Constitution Petition number 73 of 2007 shall be proceeded against under Article 209 of the Constitution. The Secretary of the Law Division of the Government of Pakistan shall take steps in the matter accordingly. 11. It is also important to mention that Justice Ghulam Safdar Shah, who wrote dissenting judgment in the Supreme Court, was subsequently witch-hunted and ultimately he had to leave the country in a miserable condition. 12. whether it was legally justified to award capital punishment to Shahid Zulfikar Ali Bhutto in the absence of any evidence worth name and merely on the basis of a totally cooked up and maneuvered story which never stood the test of routine cross-examination. 13. Whether both the Lahore High Court as well as Supreme Court were justified in awarding and maintaining the death sentence to Shahid Zulfikar Ali Bhutto on the basis of a so-called threat to complainant which was blown out of proportion. 14. All important cases bearing important questions of law become legal precedents for the time to come, and they are quoted as citations, whereas the case of Shahid Zulfikar Ali Bhutto is neither cited nor allowed to be quoted as a legal precedent by the courts of law. It is a judicial murder continuously haunting conscience of independent nation and legal judicial circles and hierarchies. 15. The unconstitutional and illegal ouster of Shahid Zulfikar Ali Bhutto by a tyrant dictator and subsequent events was the root cause of initiation of an unprecedented criminal prosecution against deposed Prime Minister Shahid Zulfikar Ali Bhutto. It is a matter of record which has been evidenced through the public statements of the cronies of tyrant dictator that he wanted to get rid of Qaeda-e-Awam by all means. The use of judiciary for execution of his malicious designs should not remain part of our legal history, as this country has started treading the path of democracy under an independent and proactive judiciary which has shown its resolve to defeat and foil any attempt to undermine or subvert the constitution of the Islamic Republic of Pakistan. 16. Was it not legal duty of the regime to conduct an independent and fair judicial inquiry into the incident before starting criminal prosecution against Shahid Zulfikar Ali Bhutto? 17. Was it safe administration of justice to award capital punishment to an accused of conspiracy for murder against whom the essential ingredients of conspiracy were not proved through reliable evidence? 18. Whether justice can be seen to have been done in this case while the appellant was deprived of his right of appeal before the High Court, being tried directly by the High Court. 19. Had he been tried by a sessions court, the trial judge would have been legally bound to follow the case law developed up to the time of trial, whereas the High Court ignored the same altogether. In this case, up to the time of trial and conviction, there was absolutely no precedent of conviction and sentence of capital punishment on the testimony of a prover. Neither in the judicial history of this country, murder trial of an accused was conducted by the High Court in its original jurisdiction, thereby denying the accused a valuable right of appeal before the High Court. The trial in this case was akin to the trial of Bhagat Singh, who too was tried, convicted and sentenced in Lahore on the testimony of a prover. 20. The judgment is per inquirium. According to Black's Law Dictionary, a judicial decision wrongly made is termed as per inquirium. The very fact that three honorable judges, Mr. Justice Ghulam Sattar Shah, Mr. Justice Dura Patel, and Mr. Justice Muhammad Halim, out of 7 gave a dissenting view, whereas 4 handpicked judges acted under the dictates of tyrant dictator, which makes it imperative for the Supreme Court of Pakistan to re-examine the law on the point of a prover and criminal conspiracy. 21. It has been ruled by the Honorable Supreme Court of Pakistan in the case of Federation of Pakistan and others versus Mia Muhammad Nawaz Sharif, PLD 2009, Supreme Court 284, as below. Law is not a static object. It has to cope with the modern ideas and concepts and the disputes coming before the court for resolution, as the society with its environmental setup is continuously progressing. Law as well as its remedies are also changing with passage of time. 22. The question of bias needs to be revisited by the Supreme Court of Pakistan in the light of its judgment in the case of Asif Ali Zardari versus the state, PLD 2001, Supreme Court 685. 23. It was a split judgment of